Hello, everyone. My name is Cecilia Lynch, and I am a member of the ISA's Academic Freedom Committee, and I will be moderating and chairing this panel today. This is the second panel in a series co-hosted by the ISA's Academic Freedom Committee and the American Association of University Professors, or AAUP's, Center for the Defense of Academic Freedom. As we know, the ability to teach, research, and speak on issues of public importance without fear of retaliation is a cornerstone of what academics do. Without this, universities and professors cannot serve the common good. The second panel in our series explores academic freedom and international institutions. What academic freedom means varies around the world, often emerging from specific institutional and legislative contexts and legal structures. Different international and regional organizations have developed their own articulations of academic freedom. This panel examines how academic freedom is articulated by the AAUP, the UN, and the Coalition for Academic Freedom in Southeast Asia. Our goal is to discuss important similarities and differences among the various articulations of academic freedom, while thinking about how the International Studies Association, as a professional association with scholars from around the world, might understand and engage with its commitment to academic freedom at an associational level. I want to tell you a little bit about the Academic Freedom Committee of the ISA and its work. The AFC was created by ISA's Governing Council in 2009. It is charged with protecting the academic freedom of scholars in all disciplines related to international studies. That is, beginning with, but not limited to, members of ISA. The AFC receives information about violations of academic freedom, makes a judgment as to their merits, and then recommends to the ISA Executive Committee a position for ISA to take. In addition, the AFC may publicize the threat or violation through official ISA newsletters and other relevant means in consultation with the ISA president and executive director. This is important work because most of the scholars who experience threats to their academic freedom have very few options. Most cannot leave their institution or their country, so we need to advocate on their behalf. The AFC may also recommend that ISA join the official advocacy efforts of peer organizations or express its concern directly to relevant government officials and international bodies. If there is anyone in this audience who wants to reach us, our email is academic-freedom@isanet.org, academic-freedom@isanet.org, and that will be dropped into the chat right now. We have four very distinguished panelists today. I'm going to introduce them all, and then each will speak for about 10 minutes, after which we'll open up the discussion to questions. Our first is Bencharat Seshua, who is the director of the Southeast Asia Coalition for Academic Freedom and lecturer at the Institute of Human Rights and Peace Studies, Mayudol University. Our second speaker is Isaac Kamola, director of the AAUP's Center for the Defense of Academic Freedom and professor of political science at Trinity College. Our third is David Kaye, professor of law at the University of California, Irvine, and former UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression. And our fourth speaker is Michael Link, professor emeritus at the Faculty of Law, Western University, Ontario, and former United Nations Special Rapporteur for the situation of human rights in the occupied Palestinian territory. I want to thank you all for being with us today, and we will begin with Bencharat Seshua for 10 minutes. Thank you.
Thank you, Cecilia. Thank you for having me to join this panel on this very important period of time to discuss the issue of academic freedom. What I'm going to share with you in this 10 minutes is to look at how we discuss the issue of academic freedom in Southeast Asia And I would like to highlight the aspect that may not come up much in our discussion about threat, about democratic backsliding, about suppression on academic freedom, because I would like to draw your attention to the control or the political ideology that control what can be spoken in Southeast Asia, and those issues are those that have impact on academic freedom. The violation of academic freedom is not always outright. There are subtle forms of violation of academic freedom that reflect the state of democracy, democratic values, or human rights value in the region, and it's vice versa. When we look at Southeast Asia, we are in the region where critical thinking is not always valued and often suppressed, and human rights and democratic values are not very deep rooted in the culture and political system. And when we apply that to look at the education institution and the role of the education in the society, we can even see this even further. So apart from like killings, violence, disappearance, imprisonment, persecution, loss of position and travel restriction, like the one that the scholar at risk, academic freedom monitoring index monitoring, everyday academic works are also restricted through and controlled by institution and national research policy, national security policy, national development goal, or academic quality assurance system, or even the business model of education that value income generation and not knowledge production. Books are banned, research on certain issues are not supported, be they especially those the so-called sensitive issue in different political contexts. And not only education is commercialized, but military is also interfering into education in some countries, and I will talk more about this later. I think I like to highlight this fact because academic freedom is often defined in a politically neutral term, but academic institution and academic system, especially the university, they are not politically neutral. If we look at the UNESCO ILO recommendation concerning the status of higher education teaching personnel, it says academic freedom is the right without constriction by prescribed doctrine to freedom of teaching and discussion and so on. It is true in the sense that freedom of teaching and discussion should not be limited by certain doctrine. However, bearing in mind that education institution is not a politically neutral institution. In Southeast Asia, the university is always part of the state mechanism that has the duty to instill and create good citizens for the country. And what it means is that the knowledge, education, research, scholarly discussion are always shaped by the values that the state endorses and the knowledge and narrative that the state promotes. What it means in practice can range from the condition of the research grant that is available only for the research in in some topics, but not on many other topics. It can range to like self-censorship of the scholars, can lead to state control of the curriculums, bans on books, removal of certain contents from the textbooks. And I like to give some concrete example to highlight these cases. I like to draw your attention to where education system is dominated by nationalist ideology, especially in Southeast Asia, where it is a region of diverse ethnic groups and in countries where there are political conflicts. For example, discussion on certain ethnic minorities or minority identities in some countries are kind of taboo and not allowed and may not exist at all. For example, discussion on the group of Cham, Khmer Krom, or Vietnamese in Khmer, in Cambodia is not possible. In Timor-Leste, the researcher would need to get a permission from the National Institute for Linguistics before they can study any local languages. And the whole process will slow down or even limit academic research. discussion on ethnic group fighting for independence or those ethnic groups fighting against central government is a very sensitive topic. Again, even in East Timor, the discussion about West Papua in Indonesia or different groups in Myanmar are kind of prohibited or too sensitive to be discussed among Timor-Leste academics. This is probably because of the geopolitics and international relations where Timor-Leste want to be friendly with other countries in the region. So these are just some of the examples. Another issue that I like to highlight about academic freedom in Southeast Asia and which links to the issues of politically neutral or politically sensitive academic institution is that most of the academics in Southeast Asia that we are working with are what we may call activist scholars. So here we are talking about those actively engaging in a new form of knowledge production, those who attempt to bridge between the theories and practice, and those who try to create, like challenge the status quo, question the power that be, criticize the policy of the government. And these academics are engaging in different forms of political activism or involved in academic research that challenge the status quo, and they become targets of state control. With this, I would argue that the line between academic freedom and freedom of expression become blurred. And as some of us may try to separate the two to make it clear about academic freedom is the rights of the academic, but I would argue that to understand the context in Southeast Asia, we cannot really, sometimes the line is too blurred. We cannot really separate the two issues. With this background of strong activism and also with the rise of youth, the history and the rise of the youth movements in a number of countries in Southeast Asia, activist scholars are even more common these days. In particular, in Indonesia, the Philippines, and Thailand, to a certain extent in Malaysia, many of my colleagues take as their duty to engage in social changes through their academic endeavors. So what the result is that they are under attack by the state and also by the civil society who act out on behalf of the state. I like to share with you the case of a scholar from my country, Thailand, a Thai lecturer who published a book on the military and national security, the role of the military and national security, Dr. Pongthong Pawakapan from Chulalongkorn University. She was threatened to be sued by the military for defamation because her book is about their work, how they intervene in Thai politics. Once her book, which was first published in English, was translated into Thai, the military took action and they were really, really serious. They tried to even stop it even before it could be sold on the market. But if Pongthong is not a sharp critic of the military, and if she is not always given public, she has not always given public lectures and public comments on Thai politics. And if she was not one of the key academics who led the fact findings about the violent crackdown of the protesters in 2010, the military might just ignore her. But because she's a scholar activist and because she challenged the authorities in Thailand, she got sued. And luckily, there was quite a big outcry in the society, and the military kind of stepped back in that case. And there are many other cases where academics are prosecuted or harassed when they make public comments on sensitive issues, like in Thailand, in southern Thailand, or sensitive issues like climate change in Indonesia, or the rise of migrant workers, or now on the border conflict between Thailand and Cambodia, or the scholars that work on Khmer Rouge in Cambodia, scholars that work on 1965 violence in Indonesia. All these issues, very sensitive issues, are kind of prohibited, not only among public discussion, but also in school curriculum and in scholarly research. Okay, my time is running out, but last point is that the state ideology also allow militarization of education. We have seen the attempt of the military to enter into, not only physically enter into campus compound, like in the Philippines or Indonesia or in Thailand, but also to engage in the revision, how to say, the historical revisionism, when they try to change the historical narrative, especially those related to political violence or state violence of the country. And we have seen this increasingly more and more in this context of democratic backsliding. I'd like to end it here, and then we can discuss more later. Thank you.
Thank you so much, Ben Sharad. Those were amazing comments. Next, we move to Isaac Kamola.
Greetings, everybody. I am. Thanks everybody for joining us today. I would like to especially thank Sarah Dorr for helping to organize this, Kate Taylor at the Center for the Defense of Academic Freedom, who's done an amazing job keeping things going, everybody at ISA who made this possible, and also my co-panelists, who I greatly admire their work and courage and for standing up in the defense of academic freedom. I am just I'm really excited about this panel because as I get more involved in the American Association of University Professors and the defense of academic freedom within the United States, I've come to the conclusion that American understanding of higher education is very, very particular and very, very parochial in many ways. And what I want to do today is just to think a little bit about the parochialness of the American understanding of academic freedom, the way that it's practiced or not in American institutions, and then to kind of make a plea that that we need a more international understanding of academic freedom, and to kind of situate American struggles over higher education that are taking place now under the Trump regime, kind of, and use the tools of international institutions, the language and the values structures that are part of those institutions to help us in our own defense. So just like as a little bit of laying the groundwork, it's the VDEM Institute is an institution that has tracked academic freedom around the globe, has demonstrated considerable academic backsliding in academic freedom over the past decade or so, largely because of the emergence of what they call anti-liberal institutions, anti-pluralist societies, and here they name Orban and Trump, Maye and Modi and others that have really attacked the fundamental principles of academic freedom. And we've seen this especially under the second Trump administration, where the full force of the federal government is being unleashed on academic institutions. So everything from executive orders that have redefined DEI and anti-Semitism, the complete gutting and remaking of the Department of Education, including the weaponization of the civil rights law in order to be used as to punish institutions that have the audacity to try to make their campuses more inclusive of all peoples. There's also efforts to weaponize grant funding, student visas, et cetera. I think one thing that's really important for us here at the ISA is a recent decision. The University of Kentucky was under Title VI investigation, basically made an agreement, kind of capitulated to the Trump administration, and handed over a list of 1,200 organizations that it deems have been in violation of the executive orders on DEI and anti-Semitism, basically saying that it will no longer support these, and the International Studies Association is on that list. So faculties at University of Kentucky will not be able to use student fund or faculty funds, et cetera, to attend International Studies Association. I think this is just the tip of the iceberg of the way that the Trump administration is going to be using the Title VI and civil rights investigation to attack academic freedom. So here we are in this really precarious state of higher education. But the U.S. approach to academic freedom and its conceptualization and institutionalization of academic freedom is fairly particular, right? In many countries around the world, world have academic freedom written into their constitutions, oftentimes even describing education as a human right. In many countries, academic freedom is spelled out in national or state laws, clearly describing, hopefully, what kind of protections faculty should have, what the role of a professor is, what the job expectations are, what can and can't be said, et cetera. This is kind of a, it's not always this clear. I recognize, but there's this understanding that academic freedom is spelled out in national or state laws, and oftentimes academic freedom is included in collective bargaining agreements, especially in those countries in which academics have strong labor protections. However, in the United States, for various reasons, having to do with its settler colonial history, the importation of the kind of the Oxbridge model and the colonial colleges, the adversity that the fact that higher education is not in the Constitution, that there has been an allergy to federal higher education, and instead higher education is considered an issue of states' rights, right? That there is not a single place in which there is a clear definition of what academic freedom means. This became a big problem in the beginning of the 20th century when individual faculty were being targeted for their speech, socialists, communists, those who were critical of the church, those who were pacifists during the First World War and Second World War. And so the American Association of University Professors was formed as the organization that kind of laid out the argument for academic freedom and the policies that could help defend it, and basically laid out in its 1915 declaration and then later 1940 statement academic freedom understood as including three types of freedom: the freedom in research, freedom in teaching, and the freedom in what's called extramural speech, or the ability to speak as a citizen, right? But rather than this being enshrined in some sort of national law, this was a kind of normative claim about what academic freedom should be. That 1940 statement was a negotiated agreement between the American Association of University Professors, representing faculty, and what is now the American Association of Colleges and Universities, representing academic institutions and their administrators. So as a labor unionist, I think of this as a negotiated agreement between workers and management, basically defining what academic freedom is and creating the institution of tenure with its 7-year probationary period as the kind of standard. Rather than this being incorporated into a law, however, this was then kind of adopted by institutions. So during the mid-20th century, where you have this massive expansion of higher education, you get incredible amount of faculty political power because there's a great demand for academic labor. You see a lot of these kinds of principles of the institutions of tenure as we have them now being written into faculty manuals and campus policies and collective bargaining agreements, right? And over time also used and recognized in litigation and legal decisions as well. Right. But all of this is a way to say that the protection of academic freedom in the United States is really kind of tied into the policies that exist at the state for state institutions, right? But also at the level of campus policies and faculty manuals, et cetera. Now, this dramatic right-wing attack on higher education that we're seeing now is greatly is really threatened by this federal system, right? This federal attack on higher education, in which you have, especially after the Black Lives Matter protests of 2020, right, where the largest protests in American history, where you have the states like Florida and Texas really cracking down on their higher education systems. And now you have the weaponization of the federal government being deployed against academics, not only in red states with trifecta Republican control, but also in blue states and also at private institutions. I think it's really helpful to think about how to kind of use the language of international institutions as a way of kind of expanding our understanding of academic freedom. Because the understanding of academic freedom as laid out in the AAUP statements is incredibly procedural, right? The idea is academic freedom should be protected through tenure, which is a particular procedure, that it should be protected through shared governance, right? And very kind of complicated kind of institutional arrangements that allow faculty voice into the governing of academic institutions. It's very much based on the writing of reports, the analysis and collection of evidence, right? And I think that this has made academic freedom an easy target. It makes it possible to call it elitist, out of touch, a very kind of exclusive right of a handful of people. It makes it possible to mischaracterize academic freedom as the right of tenured faculty to say whatever they want without a repercussion. But I think that is really helpful at this time to think about international documents and statements that can be used to expand the way that we talk and think about academic freedom. In particular, I'm running out of time here, so I'll just throw two on the table very quickly. I'm very, very, very inspired by the recent special rapporteur on the right to education, Farida Shahid's report, in which they laid out the argument that in the United States, the special rapporteur came to the United States, did a bunch of interviews all across the country, wrote a really excellent report analyzing the state of higher education in the United States, and basically called for a recognition for the federal government and all states to consider treating education as a fundamental human right. And I think that that's a really helpful to think about kind of in our federalist society, lots of different scales at which we can push for a recognition of education as a fundamental human right. And with that would make academic freedom also a way to protect that fundamental human right. I'm also incredibly inspired by the 1990 Kampala Declaration, which was created at a Cadastria conference. And the thing that I see in the Kampala Declaration that I don't see in other places that are talking about academic freedom is this idea of not only social responsibility, but a real recognition that academic freedom is defended not only through campus policies, not only through international law, but also through struggle, right? So Article 22, the intellectual community has the responsibility to struggle for, not just it should or it could, but has the responsibility to struggle for and participate in the struggles of popular forces for their rights and emancipation. And Article 24, the intellectual community is obliged to show solidarity and give sanctuary to any member who is persecuted for his or her intellectual activity, right? So actually calling on us to think about academic freedom as a shared responsibility that requires active engagement in political struggle. So those are just some thoughts in terms of thinking through the very weird particularities of academic freedom in the United States. And I'm really looking forward to handing it over to David Kay.
Thanks so much, Isaac. David, we're looking forward to your comments.
Great. Thank you, Cecilia. And thank you, Isaac. That was a great presentation. Venturat, also, thank you both. So there are also nice segues into what I want to discuss. Let me also start by thanking ISA, AAUP, Cecilia in particular for pulling this panel together. So what I want to do is perhaps a little bit less kind of theoretical and try to drill down a little bit into the mechanisms for both kind of the creation of various norms of academic freedom and to highlight some of those norms in particular. I'm not going to do kind of a lecture about international law and academic freedom as much as a kind of identification of, let's say, three things. First, I'll start with the sources, just where do we look for definitions, statements, et cetera, of academic freedom as a matter of international human rights law. Second, I'll try to highlight some of those substantive rights. And as Venturat noted, freedom of expression tends to be a kind of central entry point for academic freedom, but it's by no means the only entry point for academic freedom. And in fact, in many ways, thinking about academic freedom solely as a freedom of expression issue would not give us nearly enough of a full picture of what academic freedom is as an international matter. And then the last thing I'll try to do is just identify a couple of advocacy points for people who might be thinking about how we engage international institutions. Okay, and I'll try to do all of this in like my remaining 6 or 7 minutes. So the first thing is to think about sources. Just very briefly, the international environment. I think many of, if not all of you on this call, would know this through your work in international institutions and just in international relations or comparative, would understand that there's a network of treaties. Excuse me, a little bit early. In Los Angeles here. There's a network of treaties that we could look to as sources for understanding academic freedom. And I'll just name a few of those. At the global level, there's the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Both of those together, and I'll talk about substantive norms in a moment, both of those together provide a pretty wide net of issues of rights that we could draw upon when we're thinking about doing advocacy around academic freedom. But it's not just, of course, the ICCPR or the ICESR, those two covenants. There are also other treaties in international law at a global level, such as the treaty, the International Convention on the Rights of the Child, the International Convention on the Elimination of All Forms of Discrimination against Women or Racial Discrimination. There's a set of less than a dozen treaties that we could draw upon when we're thinking about specific rights. But there's also, of course, a network of regional conventions, the European Convention on Human Rights, the African Charter on Human and People's Rights, the American Convention on Human Rights. So there's a set of other regional norms that we could draw upon at regional levels. Unfortunately, not as rich in Southeast Asia, as Ben Sherratt knows, of course. But in those places where we have regional covenants, sometimes we also have regional courts, such as the European Court on Human Rights or the Inter-American Commission, Inter-American Court on Human Rights, or the African Commission, African Court, and sub-regional courts that really do a lot to provide some richness to understanding how these rights might apply in academic environments. Of course, in addition to international and regional conventions, there's national jurisdictions. There are places, as Isaac was alluding to, where academic freedom is actually guaranteed as a matter of either constitutional law or as a matter of statutory law in many places around the world. And then, of course, there's civil society, which has really provided a very rich set of principles led in particular by Scholars at Risk based at NYU. And a shout out to Rob Quinn, who's led Scholars at Risk for many years, for developing a lot of those and bringing people together to develop a lot of those principles, all of which creates a network, from your treaties, which is your hard law, to the soft law of civil society, if we want to call it that, but all has a real value for creating some basic norms here. Okay, so if those are the sources, let me just say a few words about the substantive rights. Of course, from my own work involving freedom of expression as a matter of international human rights law, I'll focus first, or at least note first, the protection of the right of freedom of expression. And I want to note a couple of points about freedom of expression that I think can be very useful for those of us doing advocacy around academic freedom. So the protection under Article 19 of the ICCPR is a guarantee of everyone's right to seek, receive, and impart information and ideas of all kinds, regardless of frontiers and through any media of one's choice. So the three things I just want to highlight there are, one, it's a right that extends not only to the person imparting information, the speaker, but it's also the right of audiences, the right to seek and receive information. I think that's a really nice encapsulation of the idea that academic freedom is not only a right that applies or guarantees, the professor's right, for example, to impart information. And we could go down into details of intramural versus extramural and all that. I don't have time to do that. But it's also a protection for audiences, for students who are also participating in the generation of knowledge as well. But it's a protection for the broader community that wants access or is guaranteed access to the information, the knowledge that's generated by academics. The other point I want to mention is that it's regardless of frontiers. It's an unusual right, freedom of expression, in that it's a right that by its terms understands that the right applies across borders. So that means, an academic in Thailand, for example, has the freedom under this right to access information generated in the United States, and that's vice versa. And we could name, could be anywhere. There are over 170 states that are parties to the ICCPR, so it's a pretty broad set of rights there and opportunities for advocacy. And then the last part is that it's any media of one's choice. As you go through those sources that I mentioned before, we could also talk about these, but there are other rights that apply, right? The right to science under the ICESR, the Economic, Social, and Cultural Rights Covenant, in addition to the right to education, the right to public participation in the ICCPR, a number of other rights that we could discuss here. And I would highlight those. I'll also at the end post some links into the chat for some sources that people might have access to. The last thing I want to say, just because my time has run short, is to highlight just some areas, or at least opportunities for people to do advocacy. And I'll just mention a few of those areas. So one is UN Special Rapporteurs. UN Special Rapporteurs are part of the UN Human Rights Council, or at least appointed by the Human Rights Council, which is a part of the UN General Assembly. And special rapporteurs have a kind of unique ability to communicate directly with governments about threats to different rights that might fall under their purview. And so for people who want to do some advocacy that accesses the UN special rapporteurs are a very good kind of entry point for that. The other is treaty bodies for states that have accepted or consented to individual communications and complaints. There are treaty bodies that also provide access for doing some advocacy and even litigation in an international setting, in addition to litigation that might be pursued in the inter-American, the European, the African courts, which oftentimes, particularly in the European and inter-American context, provide real useful ways for us to think about not only developing norms, but also enforcing them through the feedback of the international, regional, and the national implementation. Okay, so I'll stop there. I'll drop a few links in a moment, and I will turn it over to my former colleague in special procedures, special rapporteur, Professor Michael Link.
Thank you so much, David. Michael.
Thank you very much for the invitation to speak. I'm really grateful both to the ISA and the AAUP for organizing this, and it's wonderful to see and be on the same panel as both David and Isaac, who I've worked with before. I'm speaking largely with respect to how academic freedom is regulated and enforced and protected in Canada. And I say that because there's two important distinctions with respect to academic freedom in Canada. First of all, I have to acknowledge that academic freedom is largely borrowed from the American experience. In particular, we refer often in our proclamations of the importance of academic freedom to both the 1915 and the 1940 statements. And that really set, if you like, the intellectual groundwork for how academic freedom as one of making its way into law and into protection. The other thing I'll say just very briefly about Canada is that education is, its administration of education, including higher education, is decentralized. The federal government, unlike the US, plays a very small role in all this. It's primarily regulated by the provinces, and we've luckily not had very many instances of where provincial governments have tried to interfere with academic freedom at the university level. I'll mention a few examples at the end that have come up recently. Primarily, academic freedom is protected by collective agreements. I believe in the United States, it's somewhere between 18 to 20% of all post-secondary faculty are unionized and therefore their rights are governed by collective agreements. In Canada, I believe it's probably around 95 to 98%. And virtually every collective agreement that a university faculty association winds up having will wind up having a strong statement with respect to the protection of academic freedom. We don't look to our Constitution, the Canadian Charter of Rights and Freedoms, for protection. There's no specific mention of academic freedom in it, and there's only been a handful of important Supreme Court of Canada decisions that have ever mentioned academic freedom, and usually only in passing. This means that when the rights and the protection of academic freedom is litigated in Canada, we're not going to the courts for the most part. We're going to labor arbitrators who are appointed as, if you like, neutrals to be able to adjudicate a difference between a university as an employer and the faculty association. All this means is that collective agreements wind up being negotiated and renegotiated every 3 to 4 years, which means that there's a flexibility built into having collective agreements being your primary legal source in a country like Canada that will wind up allowing the parties to negotiate academic freedom. And by and large, of course, it's the unions who are pushing for academic freedom to have a broad meaning. And generally, that broad meaning comes from the 4 specific features, the 4 specific freedoms that have been identified in the 1915 Declaration and the 1940 Statement on Academic Freedom by the AAUP, which means freedom of research and publication, freedom of teaching, freedom with respect to intramural expression, and freedom of extramural expression as well. Those have found their ways into many of the collective agreements that govern faculty relationships between faculty associations and universities in Canada. In addition, we do have statements, not very many of them coming from the courts, courts of appeal, Supreme Court of Canada, which do value academic freedom as an important component of the rights that Canadians wind up having. But those generally have been made in cases where academic freedom is a secondary issue. It's really to labor arbitrators that we look to. And I'll give you just one example of what a labor arbitrator has said in an important decision involving the freedom of a faculty member to be able to criticize his or her university, where one of the labor arbitrators said there are few concepts or principles more important to the healthy and vibrant functioning of a university than academic freedom. We obviously in law would have limits to what academic freedom would wind up protecting. It doesn't protect defamation. It doesn't protect incitement to violence or hate speech or discrimination. But we, again, following the American experience, have some freedom of expression decisions made by the Supreme Court of Canada over the last 35 to 40 years that we can point to with respect to how broad freedom of expression should be interpreted and applied, and how rare the exceptions to freedom of expression should be granted. All of which means that freedom of expression, these principles in general for Canadian society, are then applied to the university campus with respect to the degrees, particularly with intramural speech and extramural speech, that would protect what a university professor can wind up saying. Two principles that come out of all this, and I'm recognizing the time is short. First of all, arbitrators have accepted, for the most part, that universities are a workplace, but they're a workplace of a special nature, and it's academic freedom that makes that difference between what what a university professor is entitled to be able to say that would be different from any other type of workplace in Canada. The second thing I'll say is, I think that notwithstanding that arbitrators don't always get it perfect in adjudicating academic freedom in Canada, this is by far, I think, the preferable route, the preferable forum to litigate these issues in Canada, as opposed to, having the courts deal with it on abstract principles. The only province in Canada that actually has specific legislation to protect academic freedom is Quebec. It passed a piece of legislation in 2021 protecting academic freedom specifically. But because every single post-secondary institution in Quebec already is unionized, has collective agreements, and these collective agreements do protect academic freedom specifically and generally very broad definitions, we've seen very little litigation going to the courts with respect to this. The last thing I just want to be able to point out in the minute or so left to me is the issue with respect to threats to academic freedom, particularly in recent years. And this comes up with, I guess, the responsibility I had as special rapporteur under the UN system. It has to do with Israel and Palestine and what has been known as the Palestine exception. Certainly some of the examples that Isaac had mentioned with respect to the United States over the last 2 years arise specifically with respect to how the federal government and state governments in the United States have tried to regulate or crush or push back demonstrations, encampments, protests with respect to the issue of freedom of speech on the question of Palestine. We have not had the kind of interference by state officials, particularly with respect to provincial governments, in university affairs surrounding the issue of encampments and protests and demonstrations on Canadian campuses. They have occurred. We've had examples of in Quebec of the Minister of Education directing several post-secondary institutions that couldn't teach certain courses on Palestine because of the climate since 2023. We've had statements made by the Minister of Education in Ontario in the legislature, naming out professors that she thought in the aftermath of October 7th, 2023, had said things that deserve their dismissal or termination. But those tend to be rare examples. We've not had interference where, as far as I know, provincial governments have tried to cut funding from universities or tried to influence decisions made by universities on this particular issue. We do have cases, and indeed I'm in the midst of trying to write an academic piece on this now, with respect to professors being disciplined, even fired, doctors have been brought up with complaints in front of the professional regulatory body regulating the doctors in Ontario with respect to what they've said, attempt to ban on university campuses the slogan "from the river to the sea" with regards to this. So I think we can point to the fact that what's happened since October 2023 regarding Israel, Palestine, and Gaza on Canadian campuses has presented among the most recent and visible challenges to where we draw the lines on academic freedom in Canada. And let me end it there then, because I know we only have a short period of time left for questions.
Thank you all so very much. This has been incredibly rich. And I'm going to kick off with a couple of questions, but I think I want to move also directly to some of the questions from the chat and incorporate them, given that we really only have about 8 minutes left. But I want to start with Ben Sherratt's observation that I thought was absolutely critical, that academic freedom is talked of as politically neutral, but in fact it's not neutral. And that very often, you spoke of Southeast Asia and you spoke of militarism, nationalism, ideology, et cetera, as interfering with academic freedom and with the role of the professoriate in a way as being activists by nature, almost. And Isaac, in bringing up these sort of procedural nature of a lot of US based academic freedom discourse and adjudication, is also basically almost saying that, in my view, I guess, or maybe Isaac, are you saying that a lot of these things that Ben Sherratt talked about are actually increasingly relevant in all of our societies, right? And then David and Michael, in bringing up some specific treaties and how Canada works with things, one of the things that made me think of is both the violations of academic freedom on the national level that Ben Sherratt was talking about, and that Michael has also talked about Canada vis-a-vis, say, the US, but also the violations of academic freedom on the university level, which we see happening, more and more. Isaac brought up Columbia, for example, my alma mater, and we can talk about more and more cases. And I'm wondering if, David, you think that it makes any sense at all for universities in different parts of the world, including the US, to appeal to these international charters. How is our university going to react to that, for example, in procedural cases? So let me throw those things out there. But I also want to talk, just to reiterate, I see several questions from participants. Let me put them all out there, and you can all choose what you want to respond to. And I'm sorry, I apologize in advance to the questioners. I'm going to try to get to the essence of the questions. So first, is the erosion of academic freedom primarily a byproduct of authoritarian drift, or does the weakening of universities actively facilitate backsliding? So I guess this is kind of which way does the arrow go, or does it go both ways? But also, I might add a twist, which is the preemptive weakening of the universities by themselves, right? Actively facilitating backsliding. A second question, does Article 19 of the ICCPR, the right of listeners, open us to political interference? So in other words, the Dear Colleague letter of the Trump administration requiring viewpoint diversity in the classroom, does the ICCPR Article 19 appear to support that kind of diversity requirement? And a twist that I would also add is, what happens when some students, some listeners say they're offended or something, they don't want to discuss this, but others welcome and want to learn, their right to learn about particular topics that, for example, Michael flagged in Quebec. And then there was another question: what international human rights standard beyond opinion and expression, or what standards are most fruitful for expanding US conceptions of academic freedom? So I want to thank these questioners. I want to thank all of you. This is amazing. And I've given you 4, but I'm going to stretch it to 5 minutes. That's total, not each, to respond.
Maybe I'll say something very briefly, because a couple of questions went to international human rights law. So the first question on the Q&A, or I'm sorry, the second question asking about what other human rights standards are relevant here or might be particularly useful. I mentioned a couple of them. I would say the right to science in particular, which is a guarantee under the Economic, Social, and Cultural Rights Covenant, could be a particularly useful area for people to be thinking about. There's a lot of recent new research on the right to science, so it's actually a pretty rich area to be thinking about. And it's a right again that, in part because of the structure of that covenant, but also its combination with the right of freedom of expression, it's a right that's transborder. So it's something that you can articulate, particularly if you think about some of the stresses that Isaac mentioned in the US context in terms of limiting interactions between Americans and academics outside the United States, you can, maybe deploy that a bit. On the question that was in the chat about viewpoint diversity, I mean, that's a really, really good point. I mean, what I would highlight again is that freedom of expression is not the only way of thinking about academic freedom, and also to emphasize that one of the principles that has developed in the context of human rights law is the strong principle of university, of institutional autonomy. And so, Professor Robert Post, former dean of Yale Law School, has actually written a lot about this way of thinking about academic freedom as not just a freedom of expression right, but as one that really requires us to be thinking about the way in which rights contribute to the pursuit of knowledge. And allowing kind of a free-for-all in the classroom is not one of those principles. It means that there's a significant amount of autonomy given to the teacher in order to structure that learning environment. I'll stop there. Those were great questions.
If I can jump in and just quickly add and build upon what David has said, let's keep in mind the 1997 UNESCO recommendation regarding the status of higher education teaching personnel. This is certainly a contribution to international statements, probably not yet international law, that has been particularly influential in Canada. The National Association of Faculty, the Canadian Association of University Teachers, often makes reference to the 1997 UNESCO recommendation as a starting point for talking about what rights on intramural speech, extramural speech, research, and teaching that makes up the components of academic freedom. And we've used that 1997 recommendation as a cornerstone for beginning to develop and devise and reform the provisions that we negotiate in the collective agreements on academic freedom. So I urge people to pay attention to that, because I think it has a potentially wide impact for how we as university faculty think of ourselves in terms of our rights within the sphere of academic freedom.
Thank you, Bencharat. And Isaac, do you have a 30-second?
Okay, in response to the question on whether democratic backsliding come before or after the decline of the university, I think and also reflecting on Isaac and Michael's intervention, I think it pretty much also depends on the context. Like where I think when you talk about the US or Canada, and the role of collective bargaining, you were talking about the context where at least democratic values, human rights, and freedom are already guaranteed to begin with. And therefore, you can see the decline. And then you can use the collective bargaining mechanism to defend academic freedom. But I'm speaking from the context where it's a state that violates and restricts academic freedom. And now, how can collective bargaining agreement help defending academic freedom in the context like Southeast Asia, where it's a state that the military that come into the campus and stop us from speaking or arrest us? So that's something that I think we need to contextualize and look at how different contexts and how can we think of defending this, but through different mechanisms available.
That's a great point, and I just want to build on those points, Bencharat, just really quickly. And this is why, like, instead of thinking through the language of backsliding, I think about it as a language of backlash, right? I think it's really important to say that the educational system that exists in the United States that we are worried we're losing is not one that was divine by God or didn't immaculately appear, but it was fought for and won, right? That during that the mid-20th century, the huge amounts of social protests, anti-war, free speech movement, civil rights, an incredible amount of mobilization of civil society to demand that the institutions of higher education be open to all people. And with that, this is Rod Ferguson's argument, resulted not only in a demographic transformation of higher education, but also an epistemological transformation, right? As different people were forced their way into the institutions, demand to be recognized, and demand that those institutions reflect their cultures and histories and communities in ways, that created new bodies of knowledge, and it also launched a backlash. And I think what we're seeing now is the result in the United States, but I think in other countries around the world, there's similar analogies, is that multi-decade long strategies of backlash. So just one example, the whole idea that students should pay for their education isn't just like a economic theory, but it was actually produced by libertarian think tanks like Cato Institute and others to basically say, how do we make sure another 1968 never happens on our college campuses? You make students pay, right? The neoliberalization of higher education happens at a time in which it's increasingly serving populations of color and women, minorities, immigrants, international students, right? And so the transformation of higher education, as it becomes more accessible to larger parts of population, receives this massive, well-funded, well-organized, well-orchestrated backlash. And I think that what we're living through now is a moment where the kind of that backlash is reaching a peak, and hopefully we'll be able to beat it back once again, right? I think that we defeated McCarthyism, and I hope that we can defeat Trump fascism in higher education. I think that, but it's always important for me to remember that academic freedom is a political struggle, right? In the same way that Ben Sherratt laid it out as well. And it's also particular to contexts, right? And particular to what's going on in individual countries. So thank you.
Thank you all again. Thank you so much for the audience. I do want to say, I want to give thanks once again to the AAUP, to Kate, as well as Isaac, and also to the ISA, Sarah, Hannah, Joel. And to say that we at the Academic Freedom Committee are trying to be more transparent and have on the website lists of resources. And a lot of you have put resources into the chat. Hannah and Joel and Kate, I hope that we can keep a record of all of that. And there is also a recording of this webinar, and we will try to preserve all of this and continue this discussion. Thank you again. And with that, we will close this one off. There's a lot for us to do.